Okay.
Yes, Your Honor, I can hear you.
All right, let's go on the record on DC 23-15816 K&D TriStar LLC versus Mesquite Towing Service. Counsel, make your appearances.
Good afternoon. Vittorio Moyuolo of Thomas and Sawyer PLLC for Plaintiff K&D TriStar LLC.
Yes, Your Honor, J.D. Reed and Jonathan Hernan on behalf of the defendants, Mesquite Towing Service and Mesquite Auto Impound.
All right, let's proceed.
Thank you. Good afternoon, Your Honor. This dispute concerns an auction sale of a semi-truck trailer from defendants to plaintiff, which was never delivered due to defendants' actions, which had caused the trailer to be totaled. Specifically, this was a 2021 Wabash National Dry Van trailer. Your Honor, we are asking the court to grant partial summary judgment on plaintiff's breach of contract claim for the original purchase price of the trailer, jointly and severally against defendants Mesquite Auto Impound and LLC and Mesquite Towing Service LLC for three reasons. First, no factual dispute exists with respect to both that consideration was paid by plaintiff to defendants at auction and that the trailer was never delivered to plaintiff following the auction sale. Second, the presently available documents all indicate that partial summary judgment jointly against both defendants is proper and further suggest that the two separate entities are actually potentially the alter ego of one another, all operating in tandem toward the same ends. Namely, defendants' own proffered general release and liability waiver and indemnity agreement, which identifies both LLCs collectively as Mesquite. This document was sent to plaintiff to facilitate the refund of the auction price, and defendants were requiring plaintiff to sign that release in order to receive the refund for the auction price. Third, defense counsel J.D. Reed's own email statement to me stating that we quote, "We already tendered that money," referring to the purchase price money, "to your office via check. There was an email/written response sent to your office some time ago that stated you could accept and deposit the check without it being conditioned on an accord and satisfaction." Nevertheless, still bringing this motion for these funds. And lastly, with respect to plaintiff's motion for sanctions, defendant's counsel, J.D. Reed, has misled me by stating that, quote, "I'm going to tender those funds," again referring to the purchase auction price funds, "into the registry of the court so that there is no argument or dispute related to them later on," end quote. To my knowledge, no funds have been tendered to the court. And contrarily, defendant's counsel appears firmly set in doing everything possible here to delay plaintiff's proper request for a refund of the purchase price, rather than working to resolve this undisputed portion of my client's claims and simplifying the suit. For these reasons, we respectfully request that plaintiff's motion for partial summary judgment be granted on the breach of contract claim with respect solely to the original purchase price of the auction sale, and further that attorney fees and sanctions be awarded for being required to bring this motion over this undisputed portion of plaintiff's claims.
Response?
Yeah, Your Honor. To be quite frank, it doesn't really matter today because it's inconsequential what the plaintiffs are arguing. Before the court is a motion which is procedurally and substantively defective. When I first reviewed the motion for traditional summary judgment, I had absolutely no idea what the plaintiff was moving on. I had no idea what cause of action plaintiff was moving on. It's not until today's oral argument that I understand that the plaintiff is moving on breach of contract, number one. And number two, I still don't understand whether or not we're seeking a partial breach of contract summary judgment as to liability or with respect to a single element. I can't figure it out. Additionally, I just heard some argument about alter ego liability. That's never been pled. It's not in the live pleadings. And I don't know even how we begin to start arguing some of these things. I can tell you that in response, I have pled several special exceptions. Those special exceptions relate to violations of Rule 166AC. That's the rule upon which the plaintiff has moved. All of the competent summary judgment case law states that a plaintiff or a movant they must, in order to submit a valid summary judgment motion, provide the grounds upon which they're making such motion. They are required to provide the identity and the cause of action and its elements that they're moving on. If they do not, the proper response is a special exceptions, because no respondent could possibly know what they're supposed to respond to if the movement doesn't provide them with the proper basis. And the motion for summary judgment that has been submitted to this court by the plaintiff is 100% insufficient as a matter of law. Again, there's no mention or reference to any specifically pled claim. There's no reference to any specific element.
Yeah, I'll admit when I read it, I wasn't super clear either. Why don't you share screen, Mr. I'm not sure how to say your name, Migliolo. Why don't you share screen where it does refer to this being a summary judgment on a breach of contract?
Yes, Your Honor. Let me get the button here. Your Honor, I have the motion here first. I do not believe the proposed order, which is before the court, refers specifically to plaintiff's breach of contract claim. The motion here, I don't know if we're seeing my screen presently.
I can see it.
We make specific reference to the issue of the original purchase price only. And however, I believe defense counsel is correct that the motion previously does not specify breach of contract. However, the proposed order before the court does.
So the summary judgment is denied. All right, and I understand there's a cross motion for summary judgment.
Yes, Your Honor. The defendant, Mesquite Towing Service, LLC, filed a no evidence motion for summary judgment on each cause of action and challenged each claim and each element of those claims. In response, what we got is an assertion by the plaintiff that it did not have enough evidence and needed a continuance in order to move on summary judgment, in order to respond. Well, as the court is aware, if you're going to move and you're going to request the court for a continuance, you've got to provide an affidavit. And that is provided by Rule 166AG. There's no doubt that there was zero affidavit attached to the response. There's not one. Secondly, if you look at
Was
the
there an
original motion
affidavit?
for summary judgment,
Let me just ask this: was there an affidavit provided? Counsel, Mr. Migliano.
Oh, I apologize, Your Honor. There have been the affidavits of the two individual owners of the plaintiff that were filed with plaintiff's original petition.
But
There-
not supporting the continuance motion.
In response to the no evidence summary judgment, no, Your Honor.
There was no affidavits filed whatsoever.
Not in response to this no evidence summary judgment hearing, Your Honor, no. My clients were on a long vacation over the winter holiday, and they only got back just in the last week, and there was not opportunity to prepare one.
Okay. All right, then the continuance is denied.
Your Honor, if I may respond further, I didn't know if defense counsel was finished presenting his motion. I apologize.
Yeah, go ahead.
All right. Your Honor, additionally,
No, let him go.
I'm sorry. I apologize.
Your Honor, the reason we're asking for further time period for discovery to take place is because at this early stage of the process, no formal discovery has taken place. Defendant's motion was filed 4 days after the discovery period began. Defendant's answers, but both entities' answers and their initial disclosures were filed late, and those collective initial disclosures were filed on December 18th. This motion was filed on the 22nd, immediately after the discovery period began. And so between responding to that motion and attending the hearing on it, as well as responding to and attending the hearing on the 12th on defendant's special exceptions, plaintiff has not had the opportunity to conduct discovery yet. And I would ask that plaintiff not be prejudiced because it hasn't.
I totally agree with you that normally I would grant a motion for continuance, but you didn't attach any type of affidavit here. I mean, even your own affidavit, you didn't attach anything. So I don't know that I have, let's look at the rule. I don't know that I even have discretion to deny, to grant your motion.
Then I will save the remaining of my arguments until after counsel has finished presenting in motioning the court to deny defendant's motion.
Okay.
Right. Your Honor, I'll further respond. Under the Texas Rules of Civil Procedure and case law, the plaintiff, in responding to each of the challenged causes of action and each of the elements, as the court is well aware, has to point out the specific evidence which would at least provide more than a scintilla of evidence to create a factual dispute. Well, the response completely fails to point out any single element, any single claim that a factual dispute may exist with respect to. In fact, the response doesn't even reference a cause of action or an element. It does none of those things. The response is completely insufficient as a matter of law. We have provided the court with some case law in Chambers v. Allstate, and that Chambers v. Allstate case actually says that the plaintiff or a respondent in this situation has to specifically point out and tell you, okay, there's this particular piece of evidence, this affidavit, this document, and this is how it provides you with a factual dispute, and this is what it's evidence of.
Well,
It doesn't do that
I'm looking
at
at O'Connor's and the Texas Supreme Court on the motion for continuance issue says under Tenneco, which is Tenneco Inc. versus Enterprise Prod Productions, I guess, 925 Southwest 2nd 640, that when a party contends that it had not had an opportunity for discovery before a summary judgment hearing, it must file an affidavit explaining the need for further discovery or a verified motion for continuance. Did you provide a verification, counsel?
Not with respect to the need for further discovery with respect to some of the summary judgment evidence and the contents of plaintiff's motion, yes. But I would ask the court for leave to submit a further affidavit or verification on the main basis that it would pursue justice given the extremely early time period for this motion. And with the holidays and the other hearings that were set this past month, for plaintiff to have an adequate opportunity to conduct discovery into its claims. I would further note that this own court's ruling at the January 12th special exceptions hearing required plaintiff to replead with specificity only as to plaintiff's counts 3 and 4 of fraudulent inducement and money had and received, and not with respect to the counts for breach of contract and conversion.
Okay, I'm not. How does that impact what we're doing today?
It just impacts to the extent that plaintiff has properly pled its claims against defendants based on the presently available information, namely being what was previously discussed, defendants' own proffered general release document, which identified both defendants as Mesquite collectively, which was the decision by the defendants to include Mesquite Towing Service by name at its own volition, and thus involving itself in plaintiff's claims.
Okay. I don't know how to respond to that other than to say, Your Honor, with respect to the continuance issue, you just heard plaintiff's counsel tell you that as a matter of law, plaintiff was entitled to summary judgment on its breach of contract cause of action against Mesquite Towing Service. And now in the same breath, they say, well, we need more time for discovery. I don't know how you can make both of those contradicting statements by saying, I've got all the evidence right here to get a summary judgment against this individual, and then at the same hearing say, oh, I need more evidence. I need more discovery. And so I need a continuance.
Your Honor,
you have it or you don't. I mean, I can't.
Your Honor, I don't believe those two positions need reconciling. With respect to plaintiff's breach of contract claim, we believed it was plain and clear with respect to the purchase price at auction. Plaintiff's other counts require discovery to determine the extent of defendant Mesquite Towing Service's involvement, or if they are not involved at all and should be removed from the suit. But until plaintiff has had some opportunity to conduct discovery, we do not know yet with respect to counts 2, 3, and 4.
Well, Your Honor, it doesn't really matter. When they responded to the no evidence motion for summary judgment, again, they didn't provide any competent summary judgment evidence that would put in dispute any single element or claim. Period. The end. They provided an unauthenticated, unsigned draft of a release, and the only evidence that unsigned, unauthenticated release could possibly be evidence of is a mere dispute between the parties. It's not evidence of a particular element or a particular claim. Doesn't talk about any of those things. And more importantly, the plaintiff in its response doesn't point out what it's evidence of. As a matter of law, the response is simply insufficient. And I'll stand on my reply and the objections that are in there.
Your Honor, our request that defendants' no evidence motion for summary judgment be denied is not made for any purpose of baseless delay, and any error on my behalf for not providing a required affidavit in response was not made for the purpose of baseless delay. We are seeking to conduct discovery and pursue plaintiff's claims.
There's only one other issue that I'd like to bring up with the court, Your Honor. In the traditional motion for summary judgment, the plaintiff requested sanctions under Rule 215.1D, which is obviously, as the court knows, is a rule for sanctions for discovery abuse. I've never seen anybody file a Rule 215 request for sanctions against somebody in a traditional motion for summary judgment. And as the court is also aware, if the court denies the motion for sanctions under 215.1D, then unless the court finds that there are justifiable
I'm not considering the
circumstances-
I'm not considering the sanctions
Okay.
motion, so you don't really need to argue that. Counsel, I mean, there's some basic things you've got to do with summary judgments. You haven't really done those, unfortunately.
I'd ask for leave of court, Your Honor, in whatever time frame as you see necessary to properly respond.
Yeah, there's no basis for a motion for leave at this point in time. I would be completely and utterly, I'm surprised. And I'm obviously prejudiced by any motion for leave that's that's on file right now, because I don't know what even the basis would be legally for asking for additional leave. It's the same thing effectively as a motion for continuance, which you just denied. So I'm not sure I understand what the basis is.
So I'm going to go ahead and grant grant defendant's motion. Let me see. So I see an order here. I'm trying to figure out what this order is. Let me see. This order, was this prepared by you, Mr. Reed?
Yes, Your Honor, it was.
So what is this exactly? Is it uh
Well, there's a couple of things. So number one, in there, I have a denial of the traditional motion for summary judgment. Additionally, in there are the special exceptions. However, the court denied those, so it could interlineate if it chose all of the special exceptions language and just simply deny it. Further, there is
were there special exceptions? Weren't those heard at the last hearing?
no, these are different. I was specially accepting to the
Okay.
motion for summary judgment on the a basis that it was vague, on the basis that it was confusing, and that I could not figure out what plaintiff was even moving on. And so what I had to do is I had to guess in my response. And so in my response, that's what I did. I kind of guessed and put out some evidence that would and did, I believe, negate and create a fact issue as to just about any claim that they may have been moving on. And then additionally, there's some obviously evidentiary objections in that chart below at the bottom of the page.
So I'm looking at this real quick. The affidavit of Darlene Burton.
Yes, Your Honor.
Can somebody share screen that for me?
Yes, Your Honor, I can quickly. No, this is showing.
I see it. Your Honor, we made a couple of objections here.
No, I want to read the rest of it.
Okay, I apologize.
Go to the next page, please. What's your objection to the affidavit? Mr. Reed, what's your objection?
Yes, sir. Your Honor, there was no basis for or foundation for her testimony here as it relates to her ability to offer testimony on behalf of K&D TriStar. Additionally, there are several sentences in here that amount to hearsay. And additionally, to the extent that there's any documents, purported documents, they're not attached to this affidavit.
Your Honor, if I may, Darlene Burton is, as mentioned here in the affidavit, one of the two owners of the plaintiff. The D in K&D actually stands for Darlene, and the K stands for Kenya, husband and wife. And she, personal knowledge of all of these facts, being present at the auction and being plaintiff's representative throughout all of the events here.
Okay. I'm clear on what I'm ruling here. I'm going to deny both sides summary judgments on this. So just give me one. I think I've submitted one of the orders denying the plaintiff's motion, but for the defendants, anyway, just put one omnibus order denying both sides summary judgments.
Your Honor, I
And
thought that you granted the no evidence motion for summary judgment.
I've looked at it again. I'm not going to grant that. I think there's a fact issue here. So I'm going to grant both. I'm going to deny both sides summary judgment. I am going to suggest to you, Mr. Miglio, is that they've offered you the 23,000. I think maybe you should take that. It's not a ruling, but anyway, that's just my suggestion. I think that things are not going to go. That's probably your client's best day, but anyway, I don't know why you guys are fighting this much over such a small case. So see if you guys can't work it out, but if you can't, we'll go from there and get me an order that reflects all my rulings. Okay, guys.
Thank you,
Your
Judge.
Honor.
Thank you, guys.